are in this series. So today we're going to talk about family law basics and specifically court cases. The goal here is not to try to make you family law experts, but to understand the concepts and some of the issues and language that's used. Oftentimes, people applying for legal help don't know how to explain what they need help with, and that can cause a lot of confusion. So just getting everybody on this same page is a great first step. And before we move on, I do want to thank Kelsey and Audrey for having us here today. So I am Nicole Love. I am the KinCare staff attorney with the KinCare Project at Texas Legal Services Center. A little bit about TLSC. It was founded in 1981 as a statewide nonprofit organization that provides legal advice, advocacy, representation, and education to underserved people throughout the state. We have more than a dozen practice areas that we can assist people with, and KinCare is one of the sub-practice areas. So today's agenda, we're going to cram a lot into a small amount of time, but like Nikelsia said, she is going to get the PowerPoint so she can send it to whomever wants it. We also have some of those infamous think fast situations to kind of help you think through some of these situations. And let me go back to the agenda real quickly. So we're going to talk about uh, things that do not have court involvement, family court, and specifically the different kinds of common cases, and then there'll be some resources at the end. So the foundation of family law is parental rights. Two legal parents have equal rights to a child when there is no court order that says something else. Each parent has the rights and duties that are listed there, which includes physical possession, choosing where the child lives, moral and religious training, control, protecting the child from abuse and neglect, reasonable discipline, supporting the child, and consenting to medical care. There are no rules for possession of the child. And there's no rules for visits with the other parent or child support. The law expects that parents are going to work together to parent the child by agreement according to the child's best interests. If one parent doesn't want to do what the other parent wants, there's no way to force the other parent to do that unless there is a court order. Non-parents have no rights. Parents are presumed to be able to make the best decisions for their own children. Even if a non-parent has possession of the child until that person gets a court order, he or she has no legal rights to that child. So who is a legal parent? Of course, mom. All men are not a father under the legal definition. Fathers have to take an extra step to become a legal parent. They must establish what is called legal paternity before they are considered a legal parent. And sometimes trying to determine this can be a little bit complex. Paternity can be established by what's called the legal presumption, and that's when the parents are legally married. Or you can see there if a child's born within 300 days of the marriage, or a man lived with a child for the first 2 years of his life and held himself out as the father. That's when someone is presumed to be a legal father. It can also be established by acknowledgement, by filing an acknowledgement of paternity, or by signing a birth certificate, or by a court order, which is called adjudicating someone. And or a court order is also issued when someone adopts a child. An acknowledgement of paternity, which you may hear shorthand for that by lawyers, is called an AOP. It's a legal form that's signed by a man and the child's mother that states, under penalty of perjury, that the man is the child's genetic father. An AOP is usually used when the parents aren't married, but they agree on the identity of the child's father. When the AOP is completed, it's filed with the Vital Statistics Unit in Austin, and the genetic father becomes the child's legal father with all the rights and duties of a parent, with certain exceptions. Again, adjudicated means by a court order, which means adoption, or it can require a DNA test. DNA paternity tests can be used in legal proceedings, but there are specific guidelines that have to be followed to make sure that it can be used as evidence in court. So this means include detailed reports from the testing lab and affidavits attesting to the accuracy and authenticity of the test results. This does not mean that someone can use a 23andMe or an at-home DNA testing kit and just say, well, the DNA, the 23andMe test showed that he's the dad. That's not admissible in court. Unless a man falls into one of these particular categories, he is not a legal parent and therefore does not have any rights or duties that a legal parent would otherwise have. And by extension, unless the father is a legal parent, then his parents are not legally grandparents until he does something proactively to become a legal parent. A kinship caregiver, you can see by the definitions, are not a legal parent. And many dads can get those DNA tests through the AG's child support process, and we're going to talk a little bit more about that later on. When we're talking about CPS involvement, it's important to know what stage a person's case is in. Stages when CPS court is involved and when they're not involved are very, very different. Stages that don't involve CPS court are generally investigations and voluntary, what are called family-based safety services, or again, that shorthand is FBSS cases. And I put a chart here just so you could see documents that caregivers could sign or receive during these voluntary stages. In these stages, parents' rights are not taken away, but they can be asked to sign a safety plan or one of these PCSPs, which is the Parent-Child Safety Placement Plan, agreeing to let a child live somewhere else temporarily or even give voluntary authorization to a caregiver to allow that person decision-making authority while the child is with that person. These are not court orders. And a safety plan and a PCSP have automatic expiration dates. You can see the safety plan cannot exceed 30 days unless there is a specific written extension. A PCSP cannot exceed 30 days, and then it's capped at 2 extensions, so a total of 90 days. And even a voluntary authorization is renewed every 6 months unless it's revoked. If a CPS case or investigation closes, CPS may close it saying, well, there's an agreed placement, and the child is in a safe and stable home. And this can cause a lot of confusion about what that particular caregiver, what rights they may have or not have, and what they can do or not do. None of these things can be used to keep a child from a parent because they are not court orders. This is an example of what a safety plan looks like. You can see where I've highlighted that it specifically has checkboxes for whether or not the contact is going to be supervised, or the parent and child are going to reside together away from the danger. This is an example of a PCSP, or that parent-child safety placement plan. And you can see where I've highlighted again that it automatically terminates on the 30th day unless there's an additional agreement that is signed, and it can only be done twice. You can see here on the second page of that's where I've highlighted, it specifically says this agreement is entirely voluntary. And here's the example of the authorization agreement for a voluntary adult caregiver that's set out in Texas Family Code Chapter 34. And again, you can see that it is a voluntary authorization and that it does not give a voluntary adult caregiver, it does not transfer any parental rights, which means that if the parent revokes and says, I'm going to pick up my child, the caregiver must give over the child. So here's one of these think fast situations. CPS opened an investigation on mom for drug use, and mom agreed to temporarily place the child with grandma, oops, sorry about that, Grandma Ruth, using a parent-child safety placement agreement, the PCSP. Mom also signed an authorization agreement allowing Grandma Ruth to be the child's caregiver. Mom then disappeared, and CPS had no choice but to close the case. CPS told Grandma Ruth not to return the child to mom. Does Grandma Ruth now have legal rights to the child? And I'll give y'all a couple minutes. No, the CPS placement did not change anything. Grandma Ruth is going to have to go to court to get a court order. So look, just some family court basics. Family law focuses on cases involving family-related matters. Family cases are civil cases, and civil cases are disputes between a person and another person or another entity of some sort, asking for some sort of compensation, usually monetary, so usually money, or some other kind of remedy for some sort of perceived wrong. In family cases, those remedies are usually court orders that kind of set out assets and debts, or deal with a child. Criminal cases involve allegations of breaking society's laws with punishment like fines or imprisonment. Texas Family Code is what outlines the laws and rules for family matters. When cases are heard in state district courts or family courts in larger counties, or if they're CPS, sometimes they might be heard in a specific CPS court. Parties are the people that are involved in the lawsuit or the entity. Usually in family law cases, it's people. A petitioner is the person who starts the lawsuit, and a respondent is the person who's being sued. The main focus on any family case involving a child is what is in the child's best interest. So any case involving possession of the child, visits with a child, support of a child, the judge will always look at what is best to meet the child's physical, mental, and emotional needs. The Texas Supreme Court has listed factors that judges are required to look at when looking at what is in the child's best interest. And this came from a case, a particular case that was that had people that were named Holly. So these are called the Holly factors. because they named it after the case where the court made the decision and made the list. So this includes looking at what the child wants, depending on their age and their maturity level. Now, just a little bit of a warning here. That doesn't mean the judge has to do exactly what the child wants. It just means that they will take their desires into account. They look at what needs the child has and may have in the future, emotional and physical danger to the child now and down the line, ability and willingness to put the child's needs first, ability to care for the child and provide a stable living environment, the physical and mental health of the parents and or caregiver, any history of family violence or neglect by either parent or caregiver, and any reasons the parent can give about what they did or didn't do, why they did or didn't do something. Courts can look at other factors too, but the Holly factors are required for the court to look at. They can't just have a feeling about who might be a better person to take care of a child or have a feeling that maybe something's not quite right. This is because the judge needs a really clear understanding of the child's situation before they make final orders. Because once there's a final order, it's really hard to change it. So does the other person have a right to know the lawsuit is filed? Yes, parents must always be notified. The law says that anyone who files a case must serve each parent. This is called issuance of citation and service of process. This is the preparation, and this is where a legal notice is prepared by the district clerk's office to give the respondent, usually a parent or both parents, notice that a lawsuit's been filed and gives the respondent a specific legal deadline to respond, to tell the court that they are interested in what's going on and that they want to know when the court hearings are set. Service of process is legally giving the notice to the respondent. It's usually done in person by the sheriff's or constable's deputy or by a private process server. You can't just skip this step because parents can't be located. If the other parent or parents cannot be found, you have to ask permission from the court to file a notice by publication in a newspaper and a public information website that's required by the Texas Government Code. You have to make a diligent search for the other parent. This means that you have to look really, really hard for the other parent. You can't just say, well, I haven't heard from them in 10 years. I don't know where they are. That's not good enough. You have to, in these cases, provide a detailed affidavit, which is a sworn statement to the court about the ways that you tried to find the missing person. So you have to try really, really hard. We usually give a list about different ways to try to find somebody, because there are a lot of ways that maybe somebody hasn't thought about to do that. The reason that this is important is because when you serve by publication, there's a risk that the other parent may not actually find out about the case. And because of this, the law says that the other parent has 2 years to ask for a new trial. And if the parent can later show that you didn't look hard enough before you serve them by publication, then he or she may be able to get a new trial no matter how much time has passed. When serving by publication, the law says too that the person filing the suit has to hire an attorney called an attorney ad litem who has to also look for the other parent. It doesn't mean they have to represent them in the case. They are appointed to look for the parent. and then they'll file a report with the court. This protects the other parent's right to be notified about the case. And what happens is the person that's filing the suit, if an attorney ad litem has to be asked for and ordered by the court, then that person has to usually pay for that attorney. The respondent, even if they filed an affidavit of inability to pay, which is, you know, sort of a different, we could go into that, but just know that if that's something that is required, that you may have to be ready to pay anywhere from $400 to $800 or so for the attorney who's searching. The respondent can file a waiver of the right to have a copy delivered to them in person, but you can't do that until after the case is filed. Sometimes if you have parents who might be in trouble with the law or don't want a sheriff's deputy or constable coming around wherever they are, they might be willing to sign off on that kind of waiver. Or if they just don't really, haven't had participation in the child's life and they just want someone else to just go on and make the decisions. Where a case is filed, there has to be specific rules. Jurisdiction means that the court has to have the power to hear the case based on the kind of parties and the kind of lawsuit. So, for example, a family case can't be heard in criminal court because a criminal court doesn't have that power. Venue means the county or physical location where the lawsuit has to be filed. In most cases involving kids, this is the county where the child has lived for 6 months or longer. So someone can, when they get, served with a lawsuit, or even beforehand, the parties can agree to the terms of the law, of the order, but they don't have to. Parties, if they do not agree, are called contested, and they'll have to each provide evidence of their side of the argument at a final hearing. A default means that the respondent does not timely file an answer. So if they don't file something that tells the court, hey, court, I'm interested in what's going on in this case. I want to participate. I want to know when there's court hearings that are scheduled. They have to file that answer. And that tells the court they need to do what they need to do to give that person notice and a chance to tell their side of the story. A default case means that no one filed an answer, and therefore they're not going to get notified of any court hearings, meaning that they're probably automatically going to lose because they're not going to participate in the case. So some common family law cases are what are called the suit affecting the parent-child relationship, a suit affecting the parent-child relation, or a suit establishing the parent-child relationship, which are paternity cases, modifications, enforcements, termination, and adoptions, and CPS involve court cases. A suit affecting the parent-child relationship, you'll hear lawyers refer to it all the time as a SAPSR. And that's just the SAPCR. This is different than a divorce. A divorce terminates a marriage and divides assets and debts. A SAPSR addresses the issues related to the children. You can have a SAPSR inside a divorce, or it can be done solely on its own. Through a SAPSR, the judge can make orders for conservatorship, and in Texas, the legal word for custody is conservatorship. And this describes the rights, responsibilities, and duties of each person or persons raising the children. This is not the same as a guardianship, In Texas, a guardianship is done through a probate court and is usually for the purposes of dealing with a child's estate after their parents have passed away, or you have a special needs kids turning 18. In other states, it may be called a guardianship, but in Texas, if you're referring to something like this is a conservatorship. If someone talks about having JMC or a joint managing conservatorship, that does not mean that each parent has equal time. Conservatorship just addresses each parent's or person's rights and duties. A visitation or possession order says that when each parent or sometimes a non-parent has visiting rights with the child or a right to have them in their possession. Monetary support is child support, medical support, or dental support. Child support is money that a parent pays to help with the cost of raising a child. Even if there's no court order, both parents are expected to financially support their child. And a judge can order this financial support. And a parent who does not live with a child and does not help support the child may be ordered to pay back or retroactive child support to the person that cared for the child. Medical support is additional child support that a parent's ordered to pay to cover the cost of health insurance and any uninsured medical expenses. And dental support is additional support that a parent's ordered to pay to cover the reasonable cost of dental insurance or any uninsured dental expenses. There cannot be an existing order already involving the child to file an original SAPSR. And one of those things that we talked about before, those safety plans, PCSPs, Chapter 34, voluntary authorizations. Again, if someone says, I have custody, or I have temporary custody, and then they show you one of those, they do not have custody. Because remember, the only thing that can give somebody custody is a court order. And a court order, you can see here, will say it's as order, and it will be signed by a judge. So when we're talking about custody, we're talking about the decision-making responsibilities and duties. In Texas, there are two kinds of conservatorship. There's joint managing conservatorship, which is the one that the court says, unless you show me some other reason, this is what I'm going to order. And then there's sole managing conservatorship. In joint managing conservatorship, both parents or a parent and a non-parent share decision-making powers for a child. Again, this does not mean equal visitation time. The custodial parent, usually known as the CP or the primary custodial parent, chooses where the child lives, and the non-custodial parent has a possession and visitation schedule and pays child support. Usually, people fight over education, healthcare, who's going to decide where the child lives, and who gets paid child support and how much. Sole managing conservatorship is where one parent and a non-parent makes all major decisions about the child, and usually one person has the most responsibility. The person that has the least responsibility or that has limited rights and duties is called the possessory conservator in this case, and they have a possession and visitation schedule and pay child support. This sometimes happens if a parent has been deemed unfit, and that's usually due to abuse, neglect, or other harmful behaviors that can put the child at risk, or it may be simply that's what parent agreed. So there's a lot of different reasons why These two things can be ordered, but usually the court will default to the joint managing conservatorship, meaning that both parties have equal decision-making powers, except one person is usually designated as the one that can decide where the child lives. So possession and access is usually called visitation. And that's the time that each person gets to spend with the child, and it sets out exchange dates, times, and locations. Visitation can be agreed to by the parties, and the written schedule is just a fallback if they don't agree. The standard possession order, or the SPO, is the most common. It's usually the first, third, and fifth weekend of the month, with Thursday evenings, alternating holidays, and extended summer visits. It usually applies to children age 3 or older. A modified possession order may happen just when the SPO doesn't work. So for example, if a parent has a work schedule that's different than normal, so maybe they work weekends, or maybe they're, work out on an oil rig or something, and have certain, they work a certain amount of days during the month, or maybe the parent's in the military. It can also, there's possession orders for children under 3. And there are supervised possession orders that the court can use if there believes that there's a risk to the child's safety. There can even be step-up plans that increase a non-custodial parent's parenting time if they do certain things like pass drug tests or attend counseling sessions. So you can see that there's a lot of different ways to do these visitation agreements. And again, people can agree, basically, even if they have an SPO in place, or a modified order, or a possession order, they can usually make agreements, even if there's a supervised order. They can make agreements, and these are fallbacks. Usually, though, if someone has a supervised possession order, there's a reason for that, and they're not going to make agreements too far outside of those. So what about grandparent visitation? We get asked about this all the time. So I thought I'd include it here, but I'm going to give a kind of a caveat here and say that KinCare does not assist with grandparent visitation issues. In Texas, grandparents do not have visitation rights unless they have a court order. And then they only have them in certain situations. And the reason for that is because the law presumes that parents act in the child's best interests. And that also means that they are presumed to be able to say who can visit their child, who their child can stay with, who can take care of the child. They have an absolute right to do that unless there is a very specific reason why not. And overcoming this particular presumption can be really difficult. Grandparents can sue for visitation if at least one of the parents has not had their parental rights terminated, the visitation is in the child's best interest, and the grandparent is a parent of the child's parent who has been incarcerated for 3 months before the petition's filed, found by a court to be incompetent. So if somebody may be in a mental health facility, the parents died, or they do not have actual or court-ordered possession of or access to the child. But again, going back to this, if the parents have had their parental rights terminated, unfortunately, that also means grandparents cannot ask for grandparent visitation. And if you want to read more about the law, it's right there in the Texas Family Code. Child support is a legal obligation of the non-custodial parent to financially support the child. This money is supposed to ensure that a child's essential needs are met. The orders are very specific, and the amount is based on the non-custodial parent's income and the number of children that might be involved. The charts here give you a really good idea of how that's calculated. Regular child support guidelines start at 20% of the monthly net resources of the non-custodial parent. But there is the possibility, if you've got a low income person who has to pay child support, for that to be adjusted down to 15% and then increasing as they go. Parents are not allowed to remain unemployed just to try to avoid child support. What happens in those cases is that the court will calculate child support based on the standard that you see there. The only way that someone can get that changed is if they provide proof that there's a reason why they shouldn't be paying that much. Child support can be modified if there are significant changes in the circumstances, and the Office of the Attorney General Child Support Division can help establish these orders. Participation by the AG's office is required if the child is on Medicaid or TANF, because those are paid by the state and federal government, and the state and federal government wants reimbursement because the parent should be paying and taking responsibility for their kids. A lot of times in our particular kinship cases, sometimes we have caregivers, and I won't say a lot of times, sometimes our caregivers don't want to rock the boat with the parents, and they'll say, well, I want to waive child support. If the AG's office is involved because the kids are on Medicaid or TANF, that's probably not something that they're going to be willing to do. There can be some very specific circumstances when child support can be lowered, like I said, or even some cases it can't be taken out of someone's check. But again, it's something that the AG's office will calculate. And then there has to be proof put on to the court about how much child support should be paid. When establishing, if the AG's office is helping establish these child support orders, they can also address custody and visitation. But if the parties disagree as to custody or visitation, the AG's not going to assist because they represent the state. They don't represent they don't represent any of the parties. So they don't represent either parent. They don't represent a caregiver. So they're basically going to say, we'll handle the child support, but if y'all are going to argue about custody or visitation, you're going to either have to do it yourself or you're going to have to hire an attorney when it comes to arguing that part in front of the judge. But the AG's office can be a really good resource for kinship caregivers who aren't eligible for any low-income programs. Can you file a SAPSR if you're a non-parent? Yes, but there are requirements that have to be proven. First, you have to have what's called standing. And this means that you have to gain the right to file this kind of case by proving that there was substantial past contact with the child and that denying access would significantly impair the child's physical health or emotional well-being. Substantial contact can mean sharing a home with the child. Usually they look at it for a year or more, providing the child's daily needs, and generally exercising the same quote unquote guidance and direction that a parent would on a day-to-day basis. So sporadic contact or just sending cards or calling once in a while, that doesn't cut it. Non-parents have to be in one of these categories. The ones that we commonly will talk about with people or put in a court petition are the ones that I've put there in italics. Someone who's had actual care, control, and possession of the child for 6 months or more. That can be tricky to calculate. It doesn't have to be, it doesn't have to be 6 months altogether, but to try to cobble that together, you might need an attorney to help you figure that out. A person who's lived with a child and a child's parent or conservator for at least 6 months and the child's parent has died, or is the child's grandparent, great-grandparent, sister, brother, aunt, uncle, niece, or nephew, if both of the parents are dead, or both the parents or the surviving parent agrees, or the child's present circumstances will harm his or her physical or emotional health. So you can see standing is not something that's automatic. What else does a non-parent have to prove? They have to overcome what's called a parental presumption of fitness. This means that the Texas law presumes that a court should grant custody of a child to the child's parents unless it finds significant reasons not to do that. A fit parent has the right to make decisions for their child, and so the court is not going to interfere with those rights unless someone can provide evidence that the parents are not fit. The courts have discussed issues that could make a parent not fit, like a history of family violence by one parent against the other, neglect or abuse of a child, drug or alcohol abuse, unsafe or unstable living conditions. So basically, it's anything that can harm the child's physical or emotional well-being. And then the non-parent has to show that they themselves are fit to care for the child. So here's another think fast situation. Grandpa Gerald is a single grandfather of his two young grandkids, ages 4 and 2. He's been caring for them for a year because mom and dad dropped the kids off at his house and disappeared. Mom and dad have never gone to court or set up child support. Do you think that mom and dad, if they came and showed back up, could come and pick the children up? They could still pick them up. The CPS safety plan is not a court order. So if he had a CPS safety plan, sorry, I skipped that part. If he had a CPS safety plan or a PCSP or even a voluntary authorization, it's still not a court order. What could he do to get legal rights and duties? He could file a SAPSER, but unless the parents agreed or fit one of those other categories, he's going to have to prove that the parents are unfit and that he can care for the kids. So a suit to establish the parent-child relationship is what can be filed to establish a legal father. If a child's father is unidentifiable, then no man has legal custody or visitation rights. This also means that no man is going to have a legal obligation to provide child support or medical support. So a suit to establish the parent-child relationship is what's used to determine a child's biological and legal father so that that child has rights to child support and has rights to inherit, and that the father has a right to participate in decision-making and visitation. So you can see it may be necessary if parents aren't married, no dad's named on the birth certificate, and no acknowledgement of paternity was signed. Usually DNA testing is ordered, but again, there has to be very specific steps. And then once that's done, then the court, and proven up in court, the court can sign an order that establishes that relationship. Until that is proven in court, that just because they took a DNA test still does not mean that that person is a legal dad and has those rights and responsibilities. If a mom or the child is receiving public or government assistance, then the AG is at some point going to open up a child support case. And if the dad needs to be established, they can request that the court put a court order for DNA testing at that time. If the mom is married to somebody else and the child is born while they are married, the man the mother is married to is presumed to be the father to the child, meaning that he is the one that has all the rights and duties. If somebody else thinks that he is the dad, or mom says somebody else is the dad, then that man doesn't have any parental rights until he goes to court to prove that he is the dad. A man who believes that he is the father still has a duty to register with the paternity registry. If somebody, again, wants to prove that a man is or is not a dad, they have to file this kind of suit. And this can be filed by itself, or it can be part of a SAPSR. So what if the father is truly unknown? The Texas Department of State Health Services, the Vital Statistics Department, again, has that paternity registry that lets a man who think that he might be the biological dad file a claim that will help him preserve his rights as a parent should a case ever be filed involving that particular child. A man can do this without a mom's permission, but he only has a very short period of time to do it. He has to do it before the birth or up to 31 days after the birth. And that form doesn't establish legal paternity, so it doesn't make him the legal dad. And it doesn't add his name automatically to a birth certificate. So if a dad is truly, truly unknown, then when someone files a petition, they have to tell the court that the identity of the father is unknown. And then they have to go that extra step and search the paternity registry to make sure that a person has not registered and said, I think I'm the dad, because in that case, that person would have to be served with the lawsuit. Because only certain people can request the search, the child's mom, the court, or an attorney in a termination and adoption suit, this can make gaining custody a little bit more difficult and require that extra step. Potentially, if that's done, then the unknown father's rights can be terminated. But again, that extra step has to be required. And that can make things a little bit more difficult. So you can't, again, just skip over that part if you say, well, but we don't know who the dad is. You can't just skip over. So again, these think fast situations. Sally's the aunt of a 3-year-old child and has had possession of her since the child's mom died in a car accident a year ago. The child's mom told Aunt Sally that she thought Jim was the dad, but was not sure, and he never signed a birth certificate. Jim now calls Aunt Sally and says he wants to take the child. Does she have to give him the child? No. He could have filed a notice of intent to claim paternity, but that does not make him a legal dad. What would he have to do to prove that he is the legal father? He would have to file suit to establish the parent-child relationship and may have to take a DNA test. So a petition or motion for modification is what requests a change from the last court order that involves the child. Does a court order have to stay the same until the child turns 18? Absolutely not. A lot of things can change over 18 years. Obviously, orders that worked when the child was 1 may not work when the child becomes school age or is a teenager and has school-related activities or has, homework at nighttime. Um, and maybe the child just, you know, is at the point where other things are happening. Um, there are other things may happen, like a parent may go to jail or die, or the child may go live with a non-parent. This process, again, to change this is called a petition or motion for modification. A person has to have standing in order to file this, and they have to show a material or substantial change in the circumstances and that the request is in the child's best interest. What is a material or substantial change in circumstances? The Texas Family Code has specifically set out that things like a child abuse conviction or a family violence conviction, things like a change of residence that may move one person out of state or result in a lot of increased expenses to go visit the child, or if a parent dies, things like that are substantial and material changes. Those are not the only ones, but those are really good examples. Time frame is also important. The court doesn't want somebody coming back every month asking for a change. So if somebody wants to modify less than a year from the time that the previous court order was entered, they have to file an affidavit explaining in detail why they are filing. And again, this particular suit has to be filed in front of the same court that put the previous order into place. And again, if one of these is used for a non-parent to try to gain custody from a parent who already has custody, the non-parent has to present evidence that the parent has put the child in physical or emotional danger or failed to provide proper care. And proper care would mean that there has to be evidence put in front of the court as to what exactly that proper care means. It may mean something different to a non-parent than it does to a judge. When someone's not following a court order, the process to bring this to a judge's attention so that they can take steps to ensure the order is being followed is called enforcement. And without getting too much into the legal weeds, just know that this is why court orders are drafted with so much specificity and why they're usually really, really long. You can't enforce an order that's vague, because then the person could say, well, I didn't know what I was really supposed to do. That's why you have those really long orders that are very, very specific, because when you file one of these, the court requires you to be really specific about what the person did that you're saying wasn't according to the court order and what you want the court to do about it. So again, that's why those court orders are really long. And that is also why it's really important to read that court order and refer to that court order if you have a question as to whether or not someone is following the rules or the court order itself. Because a lot of times, we talk to people and they may say, well, but they didn't do X, Y, and Z. And my first question is always, well, did you look at your court order? What does it say? And a lot of times they haven't even looked at the court order. For return of a child, there's an enforcement mechanism called the writ of habeas corpus, where basically a person can ask for the immediate return of the child because the person that has the child has no right to the child. But I just wanted to touch on that because I could probably do an entire presentation on that just by itself. Punishment for motions for enforcement can include fines, jail time, making up of parenting time, ordering back child support, So again, the court's going to want to know, what is it that you're really wanting? So again, here's one of these think fast situations. Grandma June has a SAPSR that gives her JMC with the parents. She has the right to determine where the child lives, and there's a visitation order in place, giving parents visitation during certain time periods. Mom and dad are now telling grandma she has to allow them to visit whenever they want to. Is that true? No. Unless they agree, mom and dad have to follow the visitation schedule. Mom and dad and grandma, I should say, have to agree to follow the visitation schedule. If mom and dad get new jobs working weekends and can't pick up the child at their usual times, what do they have to do to change the agreement or the court order? They have to file a modification because there's been a change in circumstances that makes the current order unworkable. So mom and dad would have to ask the court to order a change to the visitation schedule. What if they came to pick up the children at their court-ordered time and Grandma June says, well, I'm not going to let them go because they have soccer practice? Can mom and dad do anything? They can actually file a motion for enforcement, but they can't just take the children and break any laws to take the children. And they can't trespass on grandma's property. So sometimes by the time someone would file a motion for enforcement for one particular thing, it's kind of a one-time deal. But if it becomes a pattern, that's when someone may seriously want to think about filing a motion for enforcement. So termination and adoption versus a SAPSR. These are really important things to get straight in terms of their differences. There are 2 steps to adoption in Texas. For adoption, a court has to terminate a biological parent's rights to the child, and then the adoption has to be approved by the court. A SAPSR does not require that termination of rights. And the reason for that is because in an adoption, that child is going to be, by court order, that child's going to become like the biological child of the adoptive person or persons. So one of the things that I used to say when I would do adoptions is, you understand that this child is going to be like this child was born to you, like you gave birth to this child. And the answer to that should hopefully at that point be yes, because that is what happens in an adoption. That is not what happens in a SAPSR, where where a person just gets the right and gets some of those rights, duties, and responsibilities under that court order. Termination of parental rights, again, means a parent's no longer the legal parent to the child, meaning that they don't have those same rights and duties and responsibilities. This termination is considered final and it cannot be changed. It can happen with the agreement of a parent, which is called a voluntary relinquishment, or by a court finding it's in the best interest of the child to terminate one or both of the parents' rights to the child. For an adoption, both parents' rights have to be terminated. So if you've got an unknown dad or a missing parent, you're going to have to go through those steps again to serve that parent or establish that parental relationship so that the rights can be terminated. The decision to terminate is usually permanent, so the burden of proof is very high. The Texas Family Court section, particularly 161.001, currently lists 21 different possible grounds for termination. but this is like the death penalty in a parent's case. Basically, it completely cuts the legal rights of that person off. They might, be their biological parent, but they are no longer a legal parent, so they no longer have any legal rights to that child. If a child's American Indian, there's even more proof that's required because there's a federal law called the Indian Child Welfare Act, or ICWA, and the proof is more strict. Adoption requires interviews, home evaluations, assessments, and can require also some health, social, educational, and genetic reports, whereas a SAPSR doesn't require any of that. And that is why you will find that if you're doing a private adoption, which means not through a CPS case, then it's going to be really difficult to find an attorney who will do that at low cost or no cost, because those can be time consuming and expensive to do. I know of a couple of organizations that might be able to help in certain counties, but that's certainly not true for the entire state. If someone's going through a CPS case and parental rights were terminated through the CPS case, then the state can provide help, financial help for the adoption assistance. So again, when we're talking about burden of proof, you need to think about it like a scale. A burden of proof means that there's a legal standard that requires parties to provide evidence to demonstrate to a judge or jury that they should side with one person or the other. A SAPSR requires a preponderance of the evidence, which means more evidence than not. So that means if you have scales and you tip them just a little bit, then that is preponderance of the evidence. For a termination, the judge or the jury has to find by clear and convincing evidence that at least one ground for termination exists and that the termination is in the child's best interest. Clear and convincing means that there has to be strong proof that makes the judge believe that the facts are highly likely to be true, not just maybe true. So if you picture the scale tipping much further over than a preponderance of the evidence, that is clear and convincing. So here's a think fast situation. Aunt Sue and Uncle Glenn have had their nieces in their possession since Mom went to prison 5 years ago. Their dad's unknown. Mom wants to take them to take care of the children until she's released, but Aunt Sue and Uncle Glenn want to adopt the children. Can Aunt Sue and Uncle Glenn adopt the children if Mom refuses to relinquish her rights? The answer to that is yes, but they would have to go to court and have Mom's rights involuntarily terminated. They would also have to terminate the rights of the unknown dad. And again, this can be a really uphill battle. So the OAG, the Child Support Division, can help with everything that, so family court can help with everything the AG does, and many things the AG, there are many things that they can't do. What they can do is, you can see there, they can help establish custody, visitation, and child support through that child support application. They can help with modifications with child support. It's rare that they do that unless they specifically did the child support case to begin with, but it is possible. They can help with enforcement of that child support, and they can help with collecting that child support and giving out the payments. I put the website there. If someone wants to go, they have a really user-friendly website, I think, talking about how it works, how to apply, understanding what has to be done. A lot of lower income families get automatically referred to the AG when they applied for governmental benefits. And higher income families tend to hire attorneys to file custody cases in general family law court, where they might get more unique orders. The AG's office usually just puts in place those standard possession orders, unless there's some sort of maybe domestic violence issue. And even then, it's more of a, we're not going to put certain information about you in the order. But again, and they do take a while. The AG's office does. Um, if someone's doing it privately, they might be able to get orders faster, or even temporary orders if they need them. But a person without an attorney can go to family law court and represent themselves. Things a general family court can do that the AG's office cannot are divorces, most modifications, like I said, and enforcement of custody and visitation. I'm not going to go into a lot of detail here, because we could do a whole presentation just on court cases that involve CPS. But when the CPS court gets involved, there's about three different things. There's three different reasons why they usually get involved. There can be a court-ordered services case, which means the parent keeps the legal rights to the child, but the court is ordering the parent to do certain things for reunification. And reunification is the goal in these cases. It is not to give someone else custody or to give CPS custody. The parent in those situations keeps the legal rights to the child, but the child can be temporarily placed out of the home. A TMC case, which is that temporary managing conservatorship case, means that CPS has removed the child from the home and has taken temporary custody by court order. Parents do have the right to make decisions about the child, or they don't have the right to make decisions about the child in those TMC cases. The court will have the right to do that. And CPS also has the ability to make some decisions with court approval. But generally, parents do not have the rights at that point to make decisions about that particular child. But the goal, again, is to be unification, reunification. Kinship placements do happen often in these TMC cases, but they are ordered by the court. It doesn't mean that kinship caregivers have any legal rights to the child. They are just what's called placement, meaning they are just caring for the child on behalf of the state. However, if the child can't be reunified with the parents, then kinship placement is almost always considered in regard to taking what's called PMC of the child, which is permanent managing conservatorship, which means once that happens, they will have legal rights to the child. A person can intervene in a TMC case to seek custody of a child or to terminate the parental rights so they can legally adopt the child. But intervention's not necessarily easy and can't be done by everybody. After a person intervenes, that person has the right to attend court, file legal documents, present evidence, and ask the court for certain orders. But the intervener has to show that they have had substantial past contact with the child and proof that the appointment of the child's parent as the primary managing conservator would significantly impair the child's physical health or emotional development. In these types of cases, a grandparent is usually always allowed to intervene, but other folks may have to ask the court for permission, which the court can grant or deny. A non-parent, again, can file these interventions, but they have to give specific identifiable behavior or conduct of the parents why there may be that harm. And PMC means that CPS has permanent legal custody until something changes, like PMC may be given to a kinship caregiver. So resources, the Kin Care Project, we help Texas kinship caregivers raising kiddos when the children's parents can't. We started this project in February 2024, and we help with a wide variety of issues. We can help with brief legal advice, limited, and on occasion, full representation and authorizations or uncontested custody cases, assistance with public benefits, assistance with obtaining identification documents like birth certificates or social security cards, assistance with educational issues. We can draft wills and powers of attorney for a caregiver. And we help a lot with resources and education, like this presentation that we're doing today. We do not help with contested custody cases. So if a kinship caregiver has a case that they want custody and a parent is saying, no, I don't want that, that's not something that we can help with. We do not help with grandparent visitation cases. We do not help with active CPS cases. We do not help with denials of licensing. We do not help with child support or enforcement. And we do not help parent versus parent cases. If you qualify for our program, you have to be a non-parent caregiver that is in possession of the child. You don't have to have CPS involvement, but you have to have possession of that child. You cannot just want possession of a child. You have to be a US citizen or legal permanent resident. You have to be a Texas resident, and you have to have a household income of at least at or below 125% of the federal poverty guidelines. I put the chart here so you can have an example of what that means. Federal poverty guidelines are what has been calculated by the government as the number that's needed to basically maintain a family. It may be that you don't agree with those numbers, but that's what they are. So you can see here the number of people in the household, and then here what the yearly, monthly, and weekly income is. And you can find that on texaslawhelp.org. How to apply with the Kin Care Project, you can email us directly at that email there. That's a dedicated email. Or you can phone that phone line, and that is also a dedicated phone line just for Kin Care. And if you need to reach me, you can also reach me at that same email or phone number. The Family Helpline is another resource that gives free legal information regarding child protective services, abuse and neglect issues. Experienced child welfare attorneys man that helpline. There's no income limitation. People can call anonymously. They're open Monday through Friday from 9 to 6. They cannot give legal advice, but they can give tons and tons of information and talk about options that might be available to someone in that certain situation. And again, you can call anonymously, but anybody can call as long as there's some sort of CPS question or involvement. So if someone is a teacher or from an agency and has questions, they can also call that number. Texas Family Help Link is one application that someone can apply through that can automatically direct that person to what's available with the participating agencies and help direct that application directly to that agency without having to go through a bunch of different applications. Now, not all agencies are on Texas Family Help Link right now, but that's something that is being worked on. TexasLawHelp.org is an online resource for free and low-cost civil legal assistance. There is a video for non-parent caregivers, specifically at that website there, as well as other videos if someone can more easily look at a video than read. but there's tons of information there. There are self-help guides and instructions. There's ways to find legal assistance in your area. And there's the ability to live chat with a family law attorney between 10 and 2, Monday through Thursday. There's a little icon that goes in the little right-hand corner. And when someone sees that, they can click on it and talk with that family law attorney. The Texas Kin Care Primer is also on that texaslawhelp.org website. That's basically a manual for kinship caregivers to help get information they need to support themselves and their families. It's currently being updated, but it is there. So we wanted to mention it because it does give tons and tons of really good information. Other resources are the kinship navigators that can help with finding resources, giving support, and all different types of other things. Grandparents raising grandkids is another good one. Uh, the parenting order legal line, which you see here, can answer questions about child's orders, custody, visitation, and child support. The Texas, and you can live chat through that website. The Texas AG's Office Child Support Division, we listed there. The Texas Free Legal Answers is a good website where anybody can go on and ask a legal question for free. And then the State Bar of Texas Lawyer Referral Directory. Does anybody have any questions? I realize that was long and jam-packed.